for the singing of the national anthem after they have come in. Thank you. May we now have a rendition of our national anthem, please. Africa, Africa, malubala Yesu, bonolwayo, Yiswa imitanazo, yetu. Sigelela thina lusapolwayo murena buluka sitshaba sa Yesu ufekise dimthwali mazwenyemo usibudade sibuluke sitshaba Yesu sitshaba South Africa, South Africa. Ediplova nonseyena, edijitefa nonseyena, worosebe sounds the call to come together, and united we shall stand. Let us live and strive for freedom in South Africa. Thank you. You may be seated. Your Excellency, President M. Ramaphosa, the Chief Justice M. Maya, please allow me not to go through the protocol. And I mean no disrespect at all. All will soon realize why I did not do it when the Chief Justice does it. And I know, of course, the President will also do it. In my language, we say the success of a ceremony or celebration is judged by the number of people in attendance. You may slaughter a huge number of cattle and so on, but if you have all yourself to enjoy the meat, that is a total failure. Chief Justice, that is not the case here. We have birthed your baby, Chief Justice. The idea that you thought of all that while back is obviously a resounding success. That, of course, is for you to say. I may just mention that we are very happy that all arms of state are represented, the executive, the judiciary, and the legislature. And all of them are central to our constitutionalism, the Constitution, and indeed this very institution that we are celebrating today. I am truly happy, and I think I'm expressing the thoughts and ideas of my colleagues when I say so. Welcome, but of course the proper and full welcome is going to be done by my Chief Justice. Some housekeeping matters. Cell phones must please be on silent. Right across there is a tea station, and tea is available throughout the day. If you feel like just walking out silently, grabbing a cup of tea, you may do so at any time during the course of the day. And bathrooms, that way you follow the red carpet, you turn slightly to the left. Through there's an atrium. Both to the left and to the right, there are bathrooms on the ground floor and on the first floor. There will be some interpretation services, and we have English on channel 1, Arabic on channel 2, and Portuguese on channel 3. Two of the speeches that you see on the program will be pre-recordings. They are the speech by the Speaker of the National Assembly and the speech by the President of the African Court on Human and People's Rights. One other thing I should announce is that on the program you see mention of the Minister of Justice as one of the speakers. It has been arranged such that the Minister will no longer be speaking now. So the Minister instead will introduce His Excellency President Ramaphosa. I see she's happy with that, she's smiling. Now, without wasting any further time, I must take this opportunity to introduce our esteemed and honorable Chief Justice Maya, who must welcome all of you here and also make some remarks herself. This is her function. This is her opportunity. Now it looks like I'm going to be just like our president during COVID times. I, like you, Mr. President, have lost my laptop. Oh, yeah. You were one up on me. You had an iPad, yes. Apologies. I just want to quickly get the introduction. Please forgive me. Small. Yeah, that's different. Chief Justice Maya's journey is nothing short of extraordinary. Born in 1964, she has risen through the ranks of the South African judiciary to become the first woman to hold the highest judicial office in the country. The Chief Justice of the Republic of South Africa was appointed in 2024. Her appointment marks a historic milestone, not only for South Africa, but for the advancement of women in the legal profession worldwide. Her academic credentials are impressive and reflect a lifelong commitment to excellence. She holds a BProc degree from the University of Transkei, an LLB from the University of Natal, an LLM from Duke University in the United States, where she studied on the prestigious Fulbright scholarship. And I know she also likes to say, and an Ivy League school. She has been honored with 4 Doctor of Laws degrees, that is honoris causa degrees from leading universities in South Africa. Chief Justice Smaya's legal career is as diverse as it is distinguished. From humble beginnings as an attorney's clerk, court interpreter, a prosecutor, to her pivotal role as a case investigator during South Africa's first democratic elections in 1994. She has demonstrated unwavering dedication to justice and democracy. She practiced as an advocate, taught law, and served in various judicial capacities across multiple courts, including the High Court, Labor Courts, the Supreme Court of Appeal, and the Constitutional Court. Her leadership roles have included Deputy President and President of the Supreme Court of Appeal, Deputy Chief Justice, and of course now Chief Justice. She became a member of the Judicial Service Commission in 2017 and also joined the South African Judicial Education Institute the same year, reflecting as chairperson of its council, reflecting her dedication to judicial integrity and ongoing legal education. From 2017 to 2022, she also served with distinction as a member of the South African Judicial Service Commission. That's a repeat. Her influence extends beyond our borders. She now serves as Vice President of the International Association, advancing the cause of women in law around the globe. In 2020, she joined the Bosch Judicial Institute Leadership Council. In 2021, she was appointed Chancellor of the University of Mpumalanga, a role she continues to fulfill with distinction. Beyond the courtroom, Chief Justice Maya is respected. She addresses themes such as the rule of law, judicial ethical leadership, and the empowerment of women in law and society. She is the recipient of multiple prestigious awards across the globe and has participated in various international fellowships, further solidifying her place among the world's leading judicial thinkers. She is a visionary, a mentor, a fierce advocate for a judiciary and a society that reflects the full dignity of all its people. Please join me in calling upon our Chief Justice to address us. Chief Justice.
Thank you very much, Program Director, for those kind words. And unlike you and the President, I don't rely on technology. I still never gives you glitches, reliable. Program Director, please allow me to acknowledge the President of the Republic of South Africa, His Excellency, Mr. Ramaphosa, the Chairperson of the NCOP, Honorable Mayor Ntsweni Tsipane, former Presidents of the Republic of South Africa, Excellencies Mr. Mbeki and Mr. Motlanthe, the President of the African Court on Human and People's Rights, Justice Dawood Aboud, the Chief Justice of the Republic of Zimbabwe and President of the Conference of Constitutional Jurisdictions of Africa, Honorable Chief Justice Malaba, the Chief Justice of the Supreme Court of Appeal of Botswana, Honorable Chief Justice Ketlo Khetswe, the Chief Justice of Canada, the Right Honorable Chief Justice Wagner, the Chief Justice and President of the Supreme Constitutional Court of Egypt, Honorable Chief Justice Femi Iskandar-Boulos, the Chief Justice of the Kingdom of Eswatini, Chief Justice B. Mapalala, President of the Constitutional Council of Mozambique, Honorable Justice Ribeiro, the Chief Justice of the Supreme Court of Namibia, Honorable Chief Justice Chivote, the Chief Justice of Nigeria, Honorable Justice, Chief Justice Kekere Ukun, GCON, Honorable Justice Laliloa, representing the Chief Justice of the Supreme Court of Kenya, the Honorable Mr. Justice Pankaj Mittal, Judge of the Supreme Court of India, the Acting Deputy Chief Justice of the Republic of South Africa, and our Program Director, Justice Mbuiseli Russell Matanga, the Minister of Justice and Constitutional Development of the Republic of South Africa, Honorable Kupai, MP, other cabinet ministers and deputy ministers present here today, esteemed judges president and judges of the South African judiciary and other judiciaries present here today, retired chief justices and justices of the Constitutional Court of South Africa, premiers and MECs in attendance, executive mayor and mayors, chairperson and all members of the Portfolio Committee on Justice and Constitutional Development, members of the legal fraternity and academia, representatives from various government departments and Chapter 9 institutions, representatives of civil organizations, members of the media, distinguished guests, good morning. It is a distinct honor and privilege for me to stand before you this morning to welcome you on behalf of the South African judiciary to this momentous occasion that marks the celebration of the 30th anniversary of the Constitutional Court of South Africa. This celebration marks a tremendously important milestone in South Africa's constitutional democracy, and we are deeply proud and pleased to share this special moment of celebration with such an illustrious assembly of individuals, many of whom have traveled great distances from different parts of the world to join us. I am especially honored to be addressing you as the first woman Chief Justice of this esteemed court, which was inaugurated on 14 February 1995 by the late President Nelson Mandela, a moment that marked the beginning of a new era in our country's history. I wish to extend a warm welcome to our distinguished guests, starting with our first citizen, His Excellency President Ramaphosa, and former Presidents, Excellencies President Mutlande and Mbeki. We express our heartfelt gratitude for your presence this morning, which underscores the importance of this occasion. Your collective leadership, which has guided our nation through the new constitutional dispensation with wisdom, integrity, courage, and dedication. The transition to our country's democratic chapter has been marked by numerous complexities, including socio-economic challenges, institutional reforms, and the urgent need to address historical injustices. However, you have navigated these challenges with resilience and foresight, nurturing a society in healing and shaping our democracy. The legacy you have created through your leadership will undoubtedly serve as a foundation upon which future generations will build to fully achieve the ideals and aspirations envisioned by our Constitution. I'm sorry, I've just noticed that this is not my final speech. I had added things, tweaked things. Mr. President, I actually have it. Please allow me a moment to fetch my technology, my gadget. No. I would rather be true to myself than. Okay. Found it. Oh no. Oh, yeah. All right, here we go. Thank you for the indulgence. So as I was saying, you have navigated these challenges with resilience and foresight, nurturing a society in healing and successfully shaping our democracy. The legacy you have created through your leadership will undoubtedly serve as a foundation upon which future generations will build to fully achieve the ideals and aspirations envisioned by our Constitution. I also extend a hearty welcome to the leaders of the South Africa's legislative branch, led by the chairperson of the National Council of Provinces, Honorable Mtsweni Sipane. We thank you for being part of this milestone event. Your attendance reaffirms your commitment to our collective efforts to advance the vision of our Constitution. We are also very honored to welcome to our beautiful shores our esteemed international colleagues, the President of the African Court on Human People's Rights, and the Chief Justices from across the African continent and beyond, who represent a rich diversity of judicial systems and traditions rooted in constitutional principles and respect for human rights. We are profoundly grateful for the strong show of support and solidarity towards the South African judiciary, and we look forward to strengthening our ties and fostering a spirit of cooperation that will yield positive outcomes for our judiciaries and the communities we serve. Your presence undoubtedly enriches this gathering and highlights the importance of international cooperation in advancing justice, promoting the rule of law, and protecting human rights. And to all the other luminaries present here today, it is a pleasure to have all of you in our midst, and we appreciate that you have taken your valuable time to join us despite your busy schedules. There is also a small group of special individuals we are delighted to have among us today, individuals without whom this day would most likely not have been possible. Justices Richard Goldstone, Albie Sachs, Kate O'Regan, and Johan Grichler, who were members of the original panel of justices of the Constitutional Court of the Republic of South Africa. We are honored to welcome you back to this home you helped build for all of us in this country, and we express our deepest appreciation for your pioneering contributions, selfless service, and enduring commitment to the court and our country. It is truly gratifying that even beyond the years of your active tenure on the bench, you remain valiant defenders of justice, human dignity, and the Constitution. I take this opportunity in African tradition to convey my immeasurable gratitude to Acting Deputy Chief Justice Madlanga and his dedicated team comprising Justices Mhlandla, Majid, Kolapen, and Chikwi, and Acting Secretary General Potgieter from the Office of the Chief Justice for their tireless efforts in spearheading the mammoth preparations to make this day possible. To organize an event of this stature and magnitude is no small feat, and despite the numerous challenges encountered, their hard work and sleepless nights paid off, resulting in the splendor we see around us this beautiful moment. Indeed, Justice Madlanga's efforts to make this day special as recent as 3 a.m. this morning, when he was busy texting me, worrying about some loose ends that needed to be tied up, and I wondered what we could do from our beds in the very early hours of the morning. Today we gather to reflect on 30 years of constitutionalism in South Africa, a journey defined by resilience, transformation, and a commitment to healing the injustices of our past while laying the foundation for a more just, equal, and prosperous future for all. Following decades of the liberation struggle and a series of intense post-apartheid negotiations, South Africans from all walks of life came together to elect a first democratic government on 27 April 1994, marking a pivotal moment in our country's journey towards freedom and equality. This historic event was aptly accompanied by the adoption of our interim constitution, laying the foundational framework for the establishment of a democratic regime characterized by the rule of law, the protection of human rights and governance, which is accountable to the people. Subsequently, a refined and final constitution was adopted on 8 May 1996. The birth of a new nation was thus ushered in, promising its citizens a reformed society anchored in the principles of democracy, justice, and human dignity. The transition from parliamentary sovereignty to constitutional supremacy marked a profound paradigm shift, moving from a system of institutionalized racial segregation in which Parliament held unchecked power to a system where the Constitution stands as the highest authority. Under the apartheid regime, South Africa's judicial system was administered by a legislative sovereignty which required judicial officers to interpret and enforce discriminatory laws without questioning their violation of the basic principles of justice and human rights. Courts of law were used to legitimize the atrocities meted out against the majority of South Africans. Black people and women simply had no role to play in policy and lawmaking processes. In stark contrast, the framers of the Constitution sought to establish a new democratic order founded on the principle of constitutional supremacy. This principle, enshrined in both the interim and final constitutions, dictates that the Constitution is the supreme law of the Republic, binding all legislative, executive, and judicial organs of state at all levels of government. The interim constitution facilitated the fundamental restructuring of government, dismantling the apartheid structures and introducing an entrenched Bill of Rights that would serve as a benchmark for testing the validity of legislation and government action. Crucially, it established the Constitutional Court, a cornerstone of South Africa's post-apartheid democracy. This temporary legal framework laid the foundation for a system in which state power would be prescribed and limited by a supreme constitution, with the judiciary serving as its guardian. Consequently, the South African courts, in particular the Constitutional Court, were entrusted with unprecedented powers and responsibility to enforce constitutional limitations on the exercise of public power and safeguarding human rights. At the pinnacle of South Africa's judicial system, the Constitutional Court was ultimately created to function as an independent and impartial institution, tasked to ensure compliance with the provisions of the Constitution and serve as the ultimate arbiter in all constitutional matters. In 1995, the 11 newly appointed Constitutional Court judges, consisting of a president and 10 justices, found themselves in modest commercial offices not far from here, with a few books, bare shelves, and minimal resources, we are told. The court's first bench comprised a diverse group of 4 independent-minded justices who had previously served at the appeal court, 2 recently appointed judges who had made their mark in private practice, yearlessly fighting for the rights of the victims of apartheid's draconian security laws, 2 accomplished advocates, and 3 law professors who made significant contributions to human rights and social justice advocacy. Marking a notable departure from the previously white and male-dominated judiciary, the bench's composition fairly reflected, to the extent that it could, the diversity of the legal landscape of the time, with 2 women, 6 whites, 4 Africans, and 1 Asian member. This was a positive step towards achieving the constitutional promise of a transformed society and the creation of a more representative judiciary, although much work remained to be done. This trailblazing, now I've lost my place. Okay. These trailblazing justices boldly embraced the extraordinary challenge of building a court from scratch, both physically and institutionally, and crafted a foundational framework for South Africa's constitutional jurisprudence. It is an immense privilege to have 4 of these giants to share their precious insights and experiences on the establishment of the Constitutional Court as a functioning institution and the construction of our constitutional law from nothing. It is only a decade after its inauguration on Human Rights Day, 21 March 2004, that the Constitutional Court found its permanent home where we are at Constitutional Hill, which is a deeply symbolic and significant site that bears the weight of the country's complex and troubled history. For the benefit of those who do not know, this precinct was a prison complex where many freedom fighters were detained and subjected to unimaginable torture. Having it transformed into the beacon of justice and constitutional protection that it now is another beautiful memory, beautiful miracle of South Africa's extraordinary journey. And when our first democratically elected president, Nelson Rolihlahla Mandela, opened the doors of the Constitutional Court for the very first time in February 1995, his first words, which poignantly painted the profile of the courts of the previous era, were, open quote, "The last time I appeared in court was to hear whether or not I was going to be sentenced to death. Fortunately for myself and my colleagues, we were not. Today, I rise not as an accused, but on behalf of the people of South Africa, to inaugurate a court South Africa has never had, a court on which hinges the future of our democracy," close quote. South Africa's apartheid history was characterized by the systemic displacement and marginalization of indigenous populations, leaving behind a painful legacy that still continues to shape the country's social and economic landscape. The legal system of that era was manipulated to enforce discriminatory laws, institutionalize racial segregation and inequality, and bolster an unjust regime. Even after apartheid was declared a crime against humanity by the United Nations in 1973, the legal machinery continued to serve the interests of the apartheid state. The gross violations of human rights persisted, with many South Africans subjected to brutal oppression, torture, and extrajudicial killings, engraving the deep scars that still linger today. As we know, the end of this ignominious period was ultimately brought about by a combination of growing internal resistance that was marked by widespread violent protests and activism, as well as international pressure that isolated the country from the global community through economic sanctions and diplomatic exclusion. Extensive political negotiations in the early 1990s led to the release of political prisoners, including President Mandela, who advocated for peaceful change and reconciliation. As our country transitioned to democracy, there was a broad political consensus on the need to create a body of principles that would guarantee the protection of fundamental human rights of all South Africans, while clearly establishing the roles and mandates for state institutions. The road to freedom had finally begun as South Africans worked together to forge a new national identity and heal a broken society. And thus came the birth of the Constitution of the Republic of South Africa, which, as I've mentioned, was first in an interim form and later the current version, which was certified by the Constitutional Court in a rigorous process. It is established that the South African Constitution has earned international acclaim as one of the most progressive constitutions, as have the judgments of the Constitutional Court, which interpreted its provisions and charted the scope of its reach and application. This constitution is renowned for its comprehensive Bill of Rights, strong commitment to social justice and transformation, and its role in establishing democratic institutions that are accountable to the people. Constitutionalism in South Africa ensures that government power is limited and subject to the law, with the Constitution serving as the governing document. And as President Mandela defined this doctrine on the occasion of the Constitutional Court's inauguration, it means that no office and no institution can be higher than the law. The highest and the most humble in the land, all without exception, owe allegiance to the same document, the same principles. It does not matter whether you're black or white, male or female, young or old, whether you speak Tswana, Setswana, or Afrikaans, whether you are rich or poor, or ride in a smart new car or walk barefoot, whether you wear a uniform or are locked up in a cell, we all have certain basic rights, and those fundamental rights are set out in the Constitution. This expression makes clear that having a constitution alone does not secure or bring about constitutionalism, as it encompasses a broader set of principles and practices that extend beyond the written document. The first leader of this Constitutional Court, Chief Justice Arthur Charles Kassin, articulated this distinction as follows, I open quote, "A constitution is a framework for government. It defines the institutions of the state, the power vested in them, the way in which such power must be exercised, its limits and the rules that must be observed by those in whom power is vested. But when we talk of constitutionalism, we mean more than this. Constitutionalism recognizes that sovereignty resides in the people of a country and that power must be exercised in their interests and ultimately subject to their control," close quote. Indeed, a democratic government is formed by the people and exists for the benefit of the people. And to this important characteristic of constitutionalism may be added the supremacy of the law, the rule of law, human rights, separation of powers, and judicial independence. In the tripartite scheme of government established by the South African Constitution, which divides power among the legislature, the executive, and the judiciary, with each arm tasked with distinct responsibilities in setting up a functional government that serves its people, promotes accountability and transparency, and protects human rights, the courts, and in particular the Constitutional Court, have faithfully played their role as guardians of the Constitution and enforcers of its promises, diligently acting as a watchdog over executive and legislative action to ensure accountability in the work of governance and lawmaking. In seminal decisions such as SARFU, Doctors for Life, so-called Nkandla case, many others, the court reaffirmed the pivotal role that courts play to ensure that all branches of government and public office bearers adhere to their constitutional obligations. The Constitutional Court has developed a rich body of jurisprudence that has significantly shaped and transformed South Africa's legal and social fabric by setting important precedents and clarifying principles that safeguard the rule of law and human rights. In its landmark judgment in a matter it had a day after it opened on 15 February 1995, the Constitutional Court in Makwanyane, State versus Makwanyane, delivered a groundbreaking decision that set the tone and demonstrated its commitment to uphold the Constitution and protect human rights. In determining the constitutionality of the death penalty, which was a legal punishment for political dissent under apartheid, the court ruled that the death penalty was unconstitutional because it violated the basic rights to life and dignity as enshrined in the interim constitution. This decision has had significant influence in the interpretation and application of the rights to life, dignity, personal freedom, security, limitation of rights, the use of the indigenous value of Ubuntu, and the role of public opinion in adjudication. The court emphasized that our constitution must be interpreted contextually, not in isolation. The judges looked at our history of state-sanctioned violence and inequality. They consulted international human rights law, drew from indigenous values, and insisted that the Constitution must provide the full measure of protection to every individual. In Makwanyane, we saw a new vision of justice, restorative, inclusive, and rooted in human dignity. The democracy that South Africans envisioned was not just about voting rights or political freedom. It was about redress, ensuring that the legacy of apartheid's social and economic exclusion is confronted and not ignored. That is why our Bill of Rights goes beyond civil and political rights to include socio-economic rights, the rights to housing, healthcare, food, water, education, and social security. These rights speak to daily lived experiences and they reflect a core constitutional commitment that true equality requires both freedom and material justice. In cases such as Grootboom and Treatment Action Campaign, our courts affirmed that socio-economic rights are not merely aspirational. The state is required to act reasonably and progressively to realize these rights for all, particularly the poor and marginalized. And in so doing, we shine a light on the impacts of supposedly colorblind laws, which have a disproportionate effect on people who are poor and largely black. The inclusion of socio-economic rights in our constitution was a direct response to apartheid's legacy of land dispossession, forced removals, educational exclusion, and economic marginalization. The courts have played a vital role in advancing historical redress through these rights. They have recognized that inequality is not an accident, it is a legacy, and addressing it is a constitutional imperative. 30 years on, South Africa has made real strides in respect of law, governance, and constitutional accountability. We have entrenched the rule of law and judicial independence, abolished almost all, if not all, the unjust laws, and replaced them with progressive ones that are intended to entrench human rights, protect vulnerable groups, and ensure a just and equal society. There is a deep well of court judgments that have rigorously interpreted the Constitution and the law towards this end. There's a system of constitutional review in place for the ongoing assessment of the Constitution's success that enables it to respond to new needs and demands. The judiciary has been transformed to a significant degree in terms of both race and gender towards the attainment of the judiciary envisioned by the Constitution, a judiciary that reflects broadly the racial and gender composition of South Africa. We see that in the composition of the justices of the Constitutional Court, which currently comprises a majority of black judges and 4 women in the complement of 11. The second senior court in the country, the Supreme Court of Appeal, boasts a majority of women in its ranks, and both courts are led by women. These are significant gains, but the country still faces deep socioeconomic inequalities, poverty, high unemployment, educational disparities, violent crime, and unequal access to justice, and many other debilitating social ills. The judiciary itself, whilst doing all it can to discharge its constitutional responsibility with the very limited resources at its disposal, has its own serious challenges resulting mainly from being still shackled to the executive, upon which it relies entirely for its financial and administrative affairs. This poses a tremendous hurdle and logjams for the judicial system in the conduct of its work. As the custodians of the Constitution and the law, our courts are vested with enormous powers by the Constitution to ensure that there is no abuse of state power by other organs of state, and that there is proper observance of the rule of law by all persons, state institutions, and public and private entities. Judicial independence, which has 2 components, individual independence and institutional independence, respectively referring to the ability of judicial officers to act independently and impartially, and the existence of structures and guarantees to protect courts and judicial officers from interference by other branches of government, is thus of utmost importance for the courts to effectively play their crucial role and conserve an impartial judicial process. It also reinforces the confidence and respect of the public which the judiciary serves in the functioning of our courts. It is therefore imperative that the judiciary runs its affairs independently and with credibility and integrity in order to preserve its legitimacy in society. But most hearteningly, moves by the judiciary and the executive are afoot to finally fulfill the constitutional imperative of establishing a fully independent judiciary with its own institutional independence in the not so distant future. So as we navigate all these challenges in the quest for a just and equal society, and celebrate the gains along the way as we are doing today, we need to constantly remind ourselves that our task is not simply to celebrate our lauded Constitution and the laws and court judgments that it has enabled. The promises which the Constitution makes and the injunctions of the courts on those promises must convert into reality for our communities, in our schools, in our hospitals and clinics, in our workspaces, in our prisons, in our streets, in our homes. As the Constitutional Court has pointed out, our Constitution requires us to be preemptive and not only react to harmful and unlawful incidents and systems after the damage has occurred, which one often says. The cases that daily come for adjudication before our courts show that democracy is not an event, but a long-term endeavor, a continuous act of building, defending, and improving the system that we in this country chose in 1994. We, all of us equally, bear the responsibility to continue using the law and our collective will and voices to hold ourselves accountable if we are to achieve a South Africa that is not only free, but is also equal, just, humane, safe for its inhabitants, and enables them to thrive. I wish us all, and have no doubt that we are going to have a good day of celebrations. Thank you very much for your attention.
Now we must take this opportunity to thank the Chief Justice for these moving words that evoke emotion. Thank you very much, Chief Justice. We find ourselves in the difficult position that the speech of the Speaker of the National Assembly, which was supposed to be recorded and played here now, is not ready for that purpose. I wonder, but okay. Now I will call upon the Minister to introduce His Excellency, the President of the Republic of South Africa, President Matamela C. Ramaphosa. But before the Minister does that, and Minister, I pray and hope that this is not in your notes and that therefore I'm not going to steal your thunder. I ask to say this, I just cannot resist it, Mr. President. Perhaps let me say, you are known by all South Africans and anybody who did not live under a rock or in a cave, that you played a very pivotal role in the creation of our current constitutional system. But there's a short story I want to tell which relates to something I was told very reliably. And the person concerned just took off his spectacles. Now I hope some saw him. And he said, and because he's in the front row somewhere here, I want to believe that it's true. I am told, Mr. President, that you were responsible for us having the flame of democracy. But the little bit I'm interested in is that you wanted it called the eternal flame of democracy. But you lost on that, Mr. President. Some people were, had foresight and said, but what if the gas gets finished without any replenishment? There goes the eternity. So hence the name is only the flame of democracy. Minister, please introduce our president. Thank you.
Thank you very much, Judge Madlanga. You definitely did well in that one. Let me acknowledge His Excellency, the President of the Republic of South Africa, President Ramaphosa, former presidents, President Beki and President Motlanthe, Chief Justice Maya, and former Chief Justices that I've seen here, the Chairperson of the NCOP, and the Deputy Speaker of the National Assembly. Let me just safely say I stand on the established protocols so that I don't get myself into trouble because I don't have all the names Chief Justice has done, because she has done a fantastic job on that. On so momentous an occasion, I must evoke the spirit of Matiba, who in his address at the inaugural of the Constitutional Court on 14 February 1995, the then President Nelson Mandela said the following to Judge Arthur Chackelson and other members of the Constitutional Court, I quote, "Yours is the most noble task that could fall to any legal person. In the last resort, the guarantee of the fundamental rights and freedoms for which we have fought so hard for lies in your hands," unquote. Ladies and gentlemen, this noble task is one to revere, and with the threats to democracy and current geopolitics, fundamental rights and freedoms insulating our democracy and the rule of law is a responsibility to all of us. Since its establishment, the Constitutional Court has played an instrumental role in upholding the rule of law and ensuring that the principles enshrined in our Constitution are not just words on paper, but living realities that shape the lives of every South African, and it has been a powerful force in transforming our society. I stand here, Mr. President, appreciating your support and your work as you join us here today from Canada after engagement at the G7. Appreciating the leadership and guidance in ensuring that all arms of the state functions in a collaborative and independent mechanism that supports our country, but that lives to the dream of our forebears. And Mike.
They're trying to sort it out.
On a hand. Mike.
They don't have. Let me just check again.
And unfortunately, because of the translation, I can't proceed. Yes, there's translation. Okay. Thank you very much. My apologies for that. I couldn't proceed because we've got interpretation, so I've got to speak to the mic. I must continue. I'm trying to find where I stopped. The rhythm has been off. Okay. As we celebrate this day, we recognize the role and the support, President, that has been provided in ensuring that the state functions in a collaborative and independent from each other. Many, as we reflect on the journey of the past 3 decades, we honor the commitment and courage of justices who have served on this court, and as well as the countless individuals and organizations that have fought tirelessly to uphold the values of equality, dignity, and freedom. The dedication has forged a path towards a more just and equitable society. As we celebrate this milestone and appreciate the role traveled, most importantly, the different generations that have played a role and those who continue to play that role in building our country and our democracy. As the first female Chief Justice who is leading this occasion today and the celebration just addressed us, you have a Minister of Justice and Constitutional Development today here celebrating this milestone, who in 1994, Mr. President, was too young to vote. And then when this court was established, was a teenage girl. This is what this beautiful country is about. It's alive with possibilities. Mr. President, I'm not here to deliver a speech, but to present you, not to introduce you, to be able to, and request you to address the international event to celebrate 30 years of our Constitution and also its contribution to sustaining our democracy and to sustaining this beautiful country that continues to give hope to the hopeless, to give confidence in our society, in our government, but also in our institution to those that are hopeless. Mr. President, the podium is yours to address us. Thank you very much.
Program Director, Justice Malanga, Chief Justice Maya, former President Thabo Mbeki, and former President Kgalema Motlanthe, Acting Deputy Chief Justice Mbuyiseni Madlanga, Minister of Justice, who I did not know was too young to vote in 1994. You now remind me of one other minister who is on the cabinet who tried to twist Nelson Mandela's arm to get 16-year-olds to vote. And she convinced Nelson Mandela that it was correct to have 16-year-olds to vote. And it took the very strong arguments of a number of people who are here today to de-convince Nelson Mandela that 16-year-olds should not vote. So I see that you're among those who were campaigning for 16-year-olds to vote. Chief Justices from various countries who have come to our country, at the instance of our Chief Justice, who I commended earlier, that she has succeeded in inviting so many luminary Chief Justices and Justices from various other countries, and would like to applaud her for that and thank her for having done so. I'm Chairperson of the Council of Provinces, Ms. Tsipane Mutsueni, Deputy Speaker, Dr. Anil Lotriet, and members of Parliament and members of the legal fraternity and members of the diplomatic corps, representatives of political parties who are here present, and distinguished guests and ladies and gentlemen. It is for me a profound honor to be here today, together with all of you, as we mark a significant milestone in our democratic journey. This moment in many ways calls for celebration, but it calls for much more. It calls for a reflection, but also for a recommitment and for a renewed vision of constitutionalism in our country. When the Constitutional Court was established 30 years ago in a newly democratic South Africa, this in itself was a bold act. It was also a bold institutional response to a history that had denied the majority of South Africans their basic human rights. It was tasked with interpreting and safeguarding the rights enshrined in the Constitution of 1996. But its role was always more than legal. It was deeply symbolic. It was a noble symbol of our democratic order, both immortal and a legal compass. This court was established on the ruins of an oppressive legal system and was built on the grounds of a former prison, as the Chief Justice said earlier, embodying the hope that the law could become an instrument of justice rather than repression. Allow me to briefly cast my mind back to the 8th of May 1996. This was the day when the Constitution was adopted by the Constitutional Assembly. Speaking in my capacity then as chairperson of the Constitutional Assembly, I described this, our Constitution, as our new nation's birth certificate, reflecting the history from which we have emerged and the values of human dignity, equality, and freedom that we now cherish. A birth certificate affirms the existence, the identity, and the legal recognition of every human being, and indeed every citizen. It grants a person access to rights, to services, to attend school, to work, to travel, and to participate in various aspects of society's life. Just like a person cannot enjoy their rights without a birth certificate, without the Constitution, our country would be cast adrift and would be vulnerable to the excesses of unchecked power. We celebrate the existence of this court over the 30 years in which it has defended our democracy and its democratic vision, as set out in our birth certificate, our Constitution. This court has been the guardian, watching over our nation's legal constitutional health, just as a parent would attend to the health of their growing child. The establishment of the court lent legitimacy to the new order at the time when we were emerging from decades of apartheid oppression. In many ways, the court was born of struggle and hope, anchored in the belief that never again shall South Africa be governed without regard to dignity, equality, and justice for all who live in it. In the early years since democracy and well beyond, this court has contributed not just judicial validation of the constitutional order. It has elevated the consciousness of our people about their constitutional rights. It has contributed to building trust in our legal or judicial system. Through principled constitutional interpretation, it has also contributed greatly towards advancing national cohesion and reconciliation. This objective of national cohesion and reconciliation has been enhanced by the court through its decisions. It has ensured that all people in our country are treated fairly and equally under the law, thus affirming the legitimacy of the legal order and promoting a sense of belonging amongst all citizens. The progressive, far-reaching judgments handed down by this court, as we heard earlier, include Makwanyane, that abolished the death penalty, the Grootboom case that centered on the right of housing to South Africans, and the Minister of Health versus Treatment Action campaign that dealt with the right to health care and access to HIV/AIDS treatment. The Constitutional Court has developed a rich, transformative jurisprudence. These judgments are not merely legal decisions, they are decisions that have changed lives. They've also shaped our society and strengthened our democracy. The court's judgments have advanced the rights of same-sex couples, of women in traditional marriages, of the sick and infirm, and of the most marginalized members of society. They have affirmed that dignity, equality, and freedom are not reserved for the powerful, but guaranteed for all. The expansion of the court's appellate jurisdiction in 2013 to deal with matters of general public importance has further expanded the frontiers of access to justice for all. As the Constitutional Court judges, you were appointed at a time of great complexity in the life of our nation, and navigating the imperative of societal transformation back then was certainly extremely difficult. And yet the court, since its inception, set the tone for humanistic jurisprudence that continues to endure till today. The Constitutional Court, like any other institution, has had to weather many a societal and political storm. We acknowledge with deep respect the caliber of the leadership the court has drawn, jurists of independent mind, jurists of great intellect and moral courage. From the pioneering judgments of the court's early years to the complex cases of today, the judiciary has been a pillar of stability, especially in times of political uncertainty as well. The bench, again, not unlike any other sector in society, will have borne witness to the many debates around transformation, around judicial demographics, and around access to the courts by citizens. The court has at times found itself dragged into political controversies and has had to manage occasional frictions with the executive over the separation of powers. And yet, amidst all these, the Constitutional Court has not been shaken, but stood firm as a credit to the democratic order that we established. What has defined the Constitutional Court that we are proud of is not just the wisdom of its judgments, but the courage of its convictions. It has withstood political pressure, defended the separation of powers, and asserted that no person or institution is above the Constitution. It has done so with a steady voice, grounded in reason, compassion, and principle. This very building here on Constitutional Hill is a testament to that resilience. Built on the site of the old fort prison that once symbolized oppression and pain, the Constitutional Court building reflects the hopes and the aspirations of our people. Whether it is the architecture, the artwork, the interior designs, the design of the doors of the judges' chambers, or the furnishings inside the court itself, these all represent a constitutional order that lives and breathes. The success of the court which we celebrate today has been achieved through the collective effort of many. And indeed, it is a product of a judicial legal ecosystem. The legal profession, through its attorneys and judges, come to this court to present arguments that test and involve the meaning of our Constitution. The government plays a role as it bears the duty and responsibility to implement court rulings. Civil society continues to act as a vigilant watchdog and as an advocate of the voiceless in our country. The public, whose confidence in the rule of law endures, gives this court its legitimacy. We pay tribute to the justices, past and present, to the clerks of the court, legal scholars and advocates whose work has deepened our constitutional culture. Their integrity, intellect, and independence have given life to the ideals of our Constitution. And I do want to take this moment and opportunity to pay tribute to those of our founding Constitutional Court justices who are here with us today. And we pay tribute to you because you were there at the beginning. My legal advisor, Advocate Nokukanya Jele, was one of the clerks of the court, and she has related those early days to me of the cramped spaces in Bram Park where the court temporarily sat, to when the court moved to the current site in 2004 when it was still under construction. She has told me about water leaking through the skylight and dripping onto the desks and papers of a number of advocates, and about lawyers drudging up the great African steps, their fancy shoes full of mud with the wet and the dusty construction site. We thank you for having gone through all that. Must have been real suffering that you went through. At the same time, I'm sure for all who had the privilege of being part of those early days working at this court, there was a sense of elation at being part of history that was in the making, of being part of something far greater, something that all one's years of legal training and preparation had prepared them for. As a nation, we can be nothing short of immensely proud of the Constitutional Court. And this I want to say to those who have come from other countries. that this is an institution that we are immensely proud of. We are also proud of what it has achieved, and we're also proud of its ongoing and preeminent role in our society. Just as society continues to evolve and adapt, the court too has demonstrated its own capacity to interpret our Constitution in response to the lived experience and realities of our people. It has and continues to do so without fear or favor, and remains a bulwark of justice and hope. The reality we must confront is that there are significant challenges to constitutionalism today. There is a disconnect between the promise of our Constitution and the lived realities of South Africans. The promise of the Constitution is far from fully realized. Persistent inequality threats to judicial independence that are often voiced, lack of implementation of court orders, and the erosion of trust in institutions remain pressing challenges. The advancement of socio-economic rights is not as far as we wish it to be, particularly with respect to the rights of our people in relation to housing and the basic services that should sustain their lives. It will forever remain a blight on our democracy that the applicant in the groundmaking Grootboom judgment, Ms. Irene Grootboom, died in 2008 without her dream of a decent house having been fulfilled, despite her right to housing having been adjudicated by this court. Deepening respect for constitutionalism across all sectors must start with the state. We must acknowledge the troubling irony of lauding the Constitutional Court's progressive judgments on one hand, especially on socio-economic rights, with the reality that the state apparatus has in many of these cases had to be compelled by this very court to fulfill its obligations. This points to widespread and systematic shortcomings in service delivery that must be addressed. Our people should not have to resort to litigation to have their rights realized. And this is the paramount consideration. At the same time, the potential for reducing litigation against the state must be addressed, and this requires structural change. To ensure that the judiciary execute their duties independently, effectively, and with dignity, government must and will provide a range of institutional infrastructure, financial, administrative, and legal support. The support is crucial for maintaining judicial independence, which is a cornerstone of democracy and the rule of law. The 2022-2023 Judiciary Annual Report points to challenges being experienced by the Constitutional Court with respect to finalizing matters against targets. This is no doubt owing to the significant volume of cases that the court has to deal with. The 2013 challenges, or rather changes to the court's jurisdiction, have further contributed to this workload. Enhancing access to justice and improving court services has been allocated in this year's budget, and there have been increases for improving superior court services, for judicial education and support, and for filling of vacant posts and to address other funding shortfalls. Chief Justice, you will have had the Minister of Finance for the very first time in many, many years, singling out the assistance that will be given financially to the judiciary and to the Constitutional Court. I do hope that as you listened to the budget being presented in the privacy of your chambers or your home, you did applaud the Minister of Finance. I'm not asking for you to applaud him now. We reaffirm our commitment to providing all necessary support to our courts as they administer justice. At our meeting with yourself, Chief Justice, and members of the judiciary recently, we committed to taking steps to advance the independence of the judiciary. I see former Chief Justice Zondo here with us. He continuously, as he was Chief Justice, even on the last day as he was leaving, insisted that we need to reach an agreement on the independence of the judiciary. Former Chief Justice Raymond Zondo, your wish is now being fulfilled and will be fulfilled through your successor, so you can smile. A joint committee is now in action to finalize this whole process of the independence of the judiciary. It has been an anomaly of our constitutional architecture that we've had Parliament as an independent institution in our Constitution, fully and properly recognized, and the executive, but the judiciary has, on an unfair basis, had to depend on government on a variety of matters, from getting approval for the appointment of people and not even being in complete control of their own budget. This comes to an end now. The judiciary will be independent. We will ensure the judiciary is rightly constituted as an equal branch of the state, same level as government and the legislature, or the executive and the legislature. The journey traveled by this court has been a long one, and we celebrate it today. We celebrate the court's existence as a living symbol of not only justice but transformation. The court carries extraordinary mandate and weighty responsibilities, yet it has always risen to the moment. Its legacy of courage and conscience endures. Let us use this occasion not only to celebrate but to recommit. As legal professionals, you must commit to a legal profession that upholds ethics, deepens constitutional jurisprudence, and serves the public good. As government leaders, we must commit to respect the rule of law, to strengthen institutions, and to implement court decisions in good faith. And as a collective, we should ensure that the values enshrined in our Constitution continue to define our national identity and guide our development. 30 years on, the Constitutional Court remains a beacon of democracy in our country, a compass for our future journey, and may it continue to stand as a testament to justice, to accountability, and to the resilience of the people of South Africa. South Africa faces many challenges: poverty, inequality, joblessness, underdevelopment. Yet we move towards as a collective with confidence, as a people with great strength, fortified by the knowledge that the guardians of our constitutional order is continuing to develop good jurisprudence to continue guiding our democracy. As we look to the next 30 years, we should ensure that the Constitutional Court remains a living institution, an institution that is responsive, that is principled, and an institution that is deeply rooted in the values of Ubuntu, accountability, and human dignity. We do wish the court well on this auspicious occasion, and I'm rather glad that the various countries that are represented here, some of them will speak and be able to continue enriching the democracy that many of us fought so hard and for so long for. Nelson Mandela will be smiling wherever he is to see that this court, which he inaugurated, continues to exist, but continues to gain greater strength and confidence. Chief Justice, we thank you for this occasion. It is a great occasion for celebrating the work of our court, but we wish that for the next 30 years, the work of this court will have been even more enriched. Thank you very much.
Now, we have reached the end of the first session, and how fitting it is that it ends with this wonderful rendition by the head of our state. Thank you very much, Mr. President. Thank you. Let me mention that as a court and in this kind of celebration, we would have loved to have the entire first intake of justices with us here. But because some have since departed from this world, they could not be with us. What we did, which was closest to the first prize for us, was to invite their families. So we do have members or some members of the families of those departed first intake colleagues. And thank you very much to them for having accepted our invitation. We will break for tea. As we do so, there will be a photo session in which we request you, Mr. President, Minister, of course, our Chief Justice, our foreign colleagues, the Chief Justices and representatives of Chief Justices from the other countries that we have here, my colleagues at the Constitutional Court, and our retired colleagues, and the heads of court. And I request the Secretary General Advocate Potgieter, Mr. Jakes Jacobs, and Mr. Seretse to assist us when we reach that part, which is basically now. And then lastly, Here's Mr. Siretse, he'll take care because he's telling me that we'll do it in stages. So he'll please take care of that detail. One other thing I should mention is that when we come back from tea, we request all our foreign colleagues, all of them, the Chief Justices, the President, or Her Excellency from Mozambique, and all the Chief Justices to take the podium all at the same time, please, when we come back from tea, so that as soon as we are back, we can resume our program. I will hand over to the officials I mentioned to please take over. Thank you. I think it's in order that... Whilst the photo session is in progress, may I invite our guests to please walk across for tea. Thank you very much. Thank you all.
The first one on behalf of the Speaker. Thank you. Oh, excuse me.
Justice Mandisa Maya, Acting Deputy Chief Justice, we said, Justices in the Constitutional Court, members of the Judiciary, Chairperson of the National Council of Provinces, Ms. Refuda Muswe, distinguished guests, ladies and gentlemen. It is my honor and privilege to join this esteemed gathering of juries and distinguished guests in commemorating the 30th anniversary of the establishment of the Constitutional Court, the apex court of the Republic of South Africa. It is unfortunate that I'm not there with you in person because of other pressing needs of the legislature. However, I'm happy that I'm able to talk to you through video link. By their very nature, constitutions and the courts that guard them are crafted to be transformational. Around the world, constitutional courts have served as bridges from colonial rule to independence, or from oppressive regimes to new orders of freedom and democracy, as is the case in South Africa. In 1994, the Constitutional Court was established under fragile circumstances, with the deep scars of apartheid and segregation still visible across our society. It emerged amidst fear and uncertainty at the dawn of our democratic dispensation. The founding judges of the court were tasked with an extraordinary responsibility to breathe new life and hope into a divided society, to embody and uphold social and economic justice, and to lay the foundations for constitutional democracy rooted in the comprehensive rights enshrined in the Bill of Rights. From its inception, it was essential that the court reflects the diversity of South Africa. Representation in terms of gender, race, and lived experience was not merely symbolic, it was essential. This inclusivity enriched the court's capacity to deliver justice from multiple perspectives and to ground its jurisprudence in the real lived experiences of all South Africans. Over the past 3 decades, the Constitutional Court has played a central role in entrenching our constitutional democracy and safeguarding fundamental human rights. It has helped shape a participatory democracy grounded in the rule of law and social justice. Particularly in the past decades, our courts have risen to meet the growing expectations of society, transforming criticism into courage and public skepticism into legitimacy. In doing so, they've earned their place as the final arbiters of constitutionality in our republic. Of course, with such authority comes great responsibility. The duty to assess and affirm the constitutionality of laws and execute actions often leads to tensions amongst 3 arms of state. Yet this duty is critical, and the authority of the courts must be protected and respected by all South Africans. Equally, judicial office must be reserved for individuals of highest integrity and impartiality, men and women beyond reproach. To serve on the bench demands an extraordinary combination of intelligence, wisdom, composure, courage, and a deep historical consciousness. Our judges must be sensitive to our painful past while being obsessed with a future rooted in dignity, justice, and the rule of law. In the past 30 years, the Constitutional Court has delivered landmark judgments that have reshaped our society. It abolished the death penalty, protected gender equality, and upheld the rights to vote for prisoners, affirming dignity and freedom for all. In its second and third decades, the court provided clarity on the separation of powers, particularly in strengthening Parliament's oversight role and ensuring the executive remains accountable. Through its jurisprudence, the court has not only interpreted the law, but elevated our constitutional values, fostering a deeper public understanding of our democracy. Our Constitution assigns Parliament the responsibility of lawmaking and oversight, with public participation at its core. Simultaneously, it vests judicial authority in the courts. While these branches of state are distinct and independent, they are also interdependent and must support one another in service of the people. At key moments, the Constitution mandates collaboration between Parliament and the judiciary, such as during the first sitting of the National Assembly and the National Council of Provinces after election, where Chief Justice or their designee presides over the swearing in of new members and also the election of the presiding officer and thereby the president. Parliament also participate in judicial appointments and accountability through the Judicial Services Commission. The courts in turn safeguard constitutional compliance in legislation and executive action. These are built in checks and balances designed to ensure a healthy, functioning democracy. However, in recent years, we have observed a growing number of political matters and constitutional questions being decided by the court, some of which traditionally fall within Parliament's domain. This is not criticism, but rather an observation of the growing overlap between our roles at times. It is clear that this phase necessitates better collaboration and dialogue between Parliament and the judiciary. Just as Parliament benefits from the leader of private business to facilitate its relationship with the executive, perhaps the time has come to consider a common mechanism to facilitate regular structured engagement between Parliament and the judiciary, a neutral platform for reflection, dialogue, and coordination on matters of constitutional importance. As we mark this historic milestone, we acknowledge that the first decade of the Constitutional Court was pivotal in addressing social injustices and protecting human rights. The decades that followed deepened our understanding of the separation of powers, capped excesses of executive authority, and reinforced the critical oversight function of Parliament. Looking at the next 30 years, the judiciary must remain committed to the transformative vision of our Constitution, particularly in developing the common law to advance both social and economic justice. In this second term, we have already begun an intensive engagement with Chapter 9 institutions to assess how their mandates are being implemented in advancing our constitutional project. I'm confident that closer collaboration with the judiciary will enable all our democratic institutions to better fulfill their mandates and contribute
to the realization of a just, equal, and democratic society. I thank you.
Chairperson of the NCOP and the Deputy Speaker, I kindly convey our sincere gratitude to the Speaker for the presentation. Thank you. The next presentation is going to be done. It's on behalf of the President of the African Court on Human Rights and Peoples. It's done by Honorable Lady Justice B. Chafika. Thank you.
Senior President Cyril Ramaphosa, President of the Republic of South Africa, Honorable Ms. Zoko Lidiza, Speaker of the National Assembly of South Africa, Honorable Justice Mandiza Maya, Chief Justice of the Republic of South Africa, Honorable Mboloko Kubai, Minister of Justice and Constitutional Development, Honorable Justice Luke Malaba, Chief Justice, President of the Conference of Constitutional Jurisdiction of Africa, Honorable Justice Lala, Chief Justice of the Kingdom of Eswatini, Honorable Justice Kelo Getse, Chief Justice of Botswana, Honorable Justice Shibute, Chief Justice of Namibia, Honorable Justice Kekere Ekun, Chief Justice of Nigeria, Honorable Justice Richard Ordinaire, Chief Justice of Canada, Honorable Justice Justice Mbuizelu Madlanga, Acting Deputy Chief Justice, Honorable Justice Fahmi Iskandar Boulos, President of the Supreme Constitutional Court of Egypt, Honorable President Ribeiro, President of the Constitutional Council of Mozambique, Honorable Justice Mithal, Supreme Court of India, Honorable Justice Lenaula, Supreme Court of Kenya, ladies and gentlemen, all protocol observed. On behalf of the President and all judges of the African Court on Human and People's Rights, I would like, in my capacity as Vice President of the African Court, to thank you for inviting the African Court to make a speech to this very important event, the 30th anniversary of the establishment of the South African Constitutional Court. Regional integration has many components. This is particularly true when we focus on the African Union Constitutive Act, whose drafters have insisted on the integration agenda. Among others, the objectives of the African Union are to accelerate the political and socio-economic integration of the continent and to promote sustainable development at the economic, social and cultural levels, as well as the integration of African economies. Its words reminding, as indicated at the beginning, that regional integration has several components. However, it's important to flag that the judiciary plays a very important role in consolidating regional integration by many ways. Resolving disputes or issuing advisory opinion through interpretation of treaties, including human rights treaties, and ensuring compliance with the rule of law. The African Court on Human and People's Rights plays a crucial role in consolidating regional integration in Africa through its mandate, as well as through judicial diplomacy. Regional integration through the mandate of the Court. The African Court performs its mandate on two aspects: contentious jurisdiction and advisory jurisdiction. The contentious jurisdiction of the Court consists of settlement of disputes. In this regard, the Court completes the mandate of the Commission as provided by Article 2 of the Protocol. Moreover, following Article 3 of the Protocol, the jurisdiction of the Court shall extend to all cases and disputes submitted to it concerning the interpretation and the application of the Charter, the Protocol, and any other relevant human rights instrument ratified by the state concerned. The courts can be seized by the Commission or a state party. Individual and NGOs having observer status before the Banjul Commission can file application if the state concerned has made the declaration accepting the competence of the court under Article 34 sub 6 of the Protocol. To date, 12 states have made such a declaration, but 5 of them have withdrawn the same, which means that currently individuals and NGOs having observers
Seems as if that's it. Thank you. We are indebted to Lady Justice, Lady President, Vice President Justice B. Chafika for the message. I'm just going to remind the speakers on the stage that condonation has already been granted. Protocol has been observed. So we will just proceed with their presentation. The first speaker on my list will be the President of the Conference of Constitutional Jurisdictions of Africa. We normally call it the CCJA. That is the Honorable Chief Justice Luke Malaba, who is the Chief Justice of Zimbabwe. Ladies and gentlemen, may you assist me in calling the Chief Justice to the stage. Thank you.
Thank you very much, Madam Director, the Chief Justice Mandisa Maya, the Deputy Chief Justice of South Africa, all the participants here present, ladies and gentlemen. I stand before you as one of those who believe in the transformation of the wishes, the aspirations of the African people. It doesn't matter what status or position of that African is. Neither does it matter what color, origin, nationality of that person. The fact that that person is a person is a human being with the values, the principles of law to enjoy and be protected by. That is my dream. That is a kind of renaissance this man spoke about. That we must proceed as a body of the faithful. We must proceed as a body of the faithful to transform the values of the lives of these people we call Africans. That is the dream that those who fought for independence, for freedom, for equality, for the rule of law, for the independence and the impartiality of the judiciary, embodied in what we call, in glossy, beautiful words, constitutions. Glossy, beautiful words that we profoundly pronounce every day. They embodied those dreams because those dreams relate to people. They relate to the social, economic conditions of the majority of our people. They relate to the grinding poverty. They relate to the elitist abuse of power. They relate to the corruption that has become characteristic of the post-independence of our continent. So the question really is, what is the role of the judiciary? In this context of unplanned development. That was not the wish of the makers of the constitutions. The wishes, the aspirations of the makers of the constitution was to develop societies which are equitable, societies that enforce, believe in, and substantively produce equality, no matter at what level of that socio-economic position. Equality, freedom, the rule of law, where everybody is equal before the law. Those are the ideals of independence. These are the ideals of tomorrow. These are the ideals of today. These are the ideals of always. That is why we embodied them in these sacred documents, the living documents of law, to control every one of us, no matter what position we are in, including the judges themselves, must act in terms of the law. No one is above the law. Those are the basis of the legal relations embodied in these constitutions. Those are the basis of the legal relations that constitutional courts and constitutional judges, or judges everywhere, have a duty to enforce. That is our responsibility. That is why we have the independence. That is why we have this independence guaranteed, so that we can do our job without fear, favor. But is that what is happening? I speak to you as a president of the constitutional jurisdictions of Africa. Madam Chief Justice, the constitutional jurisdiction of Africa is a product of the decision of the heads of state, of member states of the African Union. Is born out of that realization of the gravity of the situation, of the need to uphold and live under the fundamental principles and values of constitutions, where human dignity is the foundation of everything, where no more again will they be apartheid. That is the kind of responsibility entrusted upon each and every member of government in Africa. No more again should we have economic power entrusted in individuals who have no commitment to the values of the Constitution, where the economic power is relying on purely the individual choice, the right to choose to be rich and be as rich as you want, regardless of the effects on the rest of others of that exercise. We don't say in Africa that there should be no exertion of the self. We don't say that there should be no enterprise. That's not what we say in Africa. We welcome enterprise. Because the very fact of improving lives of a people, there must be economic development. You cannot talk of improvement of the material conditions of existence without the economy, without the business, without business women and men. They must be there. But we say the business activity must be subjected to the fundamentals under which each one of us works. It must be subjected to the collective power. That is what our constitutions say. But we have lost it somewhere. We have lost it somewhere. Why do Africans continue to have a segment of the people suffering in poverty? Suffering in poverty, in a sea of plenty of resources. Are these fundamental questions only for politicians? No. These are fundamental questions of constitutional justice. These are the fundamental questions of constitutional justice. Who do we have in these courts? What kind of courts do we have in Africa? How do these courts operate? How do their decisions get distributed? These are the questions we, in the Conference of the Constitutional Jurisdictions of Africa, are asking. And I'm happy we are celebrating today, Madam Chief Justice. We are not just celebrating the establishment of this beautiful organization in your country, the Constitutional Court. We are celebrating the participation of gallant men and women in it, both in civil society. Those are the people who realize their obligation to mobilize, to create the public interest litigations that we are talking about, where all these landmark decisions came from. It was through action by them. And it is out of these landmark decisions that we, in this organization, realize the value. We realize the value of the African area. I want to emphasize. We realize the value of the African area of constitutional justice. That is what we stand for. We stand for upholding in this world the African area of constitutional justice. And it is there, in that belief, that we stand united and better by realizing the strength of a united, a common base of the constitutional justice of Africa. We stand stronger by realizing that. We cannot be strong if we remain segmented. That's why we are here. That's why I'm here, to participate in this demonstration, Madam Chief Justice, of the goodwill, the solidarity, because that is the basis of my organization. It's based on the realization of the need and the power of solidarity. And that should not only be solidarity of political actors. They are very important. They are drivers of policies. They are critical. But there is also checks and balances in our countries which must resonate as fundamental principles and values all over Africa. It is that we are fighting for. The commonality of the existence under the law. The commonality of the existence under the law. That is why the landmark judgments of the Constitutional Court of South Africa have been positively received in Africa. Positively received. Because they speak to the aspirations of Africans. They speak to the substantive changes that the African people want. They don't just speak to the form, the abstraction. They speak to the substantive rights. And that is where the value of the judgment of a court lie. They lie from that departure from the past, a clear break with the past, to transform and go into the future. That's why we always speak, and you speak through your judgment, of progressive realization of socio-economic rights. That is your constitution. That is what my constitution says. But why progressive realization? Because that is a dream. That is a fundamental value. That is a fundamental principle by which we must transform our society. We must move into the future for today, tomorrow, and forever. Always. That's a fundamental principle. So we must then bear the burden of upholding the rule of law. Why? Because these fundamental values on which your constitution is standing, on which the decisions of the Constitutional Court of South Africa have been based up to now. These are universal values. They are not exceptional to South Africa. They are not exceptional to South Africa. Let's not cheat ourselves. They are fundamental values guaranteeing Ubuntu, guaranteeing the Africanness. These are the values and principles that guarantee human dignity. Human dignity is the source of all these human rights we talk about. It is the source. Every freedom of expression, it originates from human dignity. Every political freedom of association originates from human dignity. Have the right to the resources, be free from poverty, it originates from human dignity. Because I'm human, I am the being, I must not be hungry. Like anyone else, the bottom line is I should never be hungry and go without food, without clothing, without shelter, just because I just have no access to the resources, which are in the hands of a few, perhaps. That's monopoly. But that has nothing to do with monopoly. Monopoly has nothing to do with human dignity. It's dehumanizing. So we must change the fundamentals and understand. And that is why we celebrate today, Madam Chief Justice, your predecessors they seem to have understood what I'm talking about. Transformation. Transform society. Transform the people. Transform the way of thinking. Even transform the judge. Because if we speak of a judge, we speak of a product of law. We speak of a creation of law. We speak of a person answering to public duty, to public office, to responsibility. We don't speak to a person answering to personal interest. That's corruption. That's corruption. Public office does not call for personal interest. It calls for duty. There's no right in a public office. There's no right in a public office. You must enforce the duties. I wish all the other branches of government understand what I'm talking about. Because if you don't, then that's when you begin to have a... Thank you very much for listening to me. I may say more and more and more, but the paper is here.
Thank you. Thank you. It's difficult to ask the Chief Justice to stop when he's still speaking. You have to show some respect. Thank you, Chief Justice, and thank you for the thought-provoking speech and for reminding us of our duties. I must applaud the CCJA members for the work that you are doing. Thank you very much. Our next speaker will talk about the two constitutions that bind us, and he will do a reflection on 30 years of judicial kingship. He is the Honorable Chief Justice Richard Wagner, who is the Chief Justice of Canada. You will have noticed that I don't do the introductions in terms of the bios. Those are available online. Thank you.
Well, thank you so much. Thank you also to Chief Justice Maya and the distinguished members of the Constitutional Court of South Africa for inviting me. It is a great honor to stand before you on the occasion of this remarkable milestone, the 30th anniversary of the South African Constitutional Court. As a fellow member of the global judicial community, I join with many others gathered here today to extend my deepest congratulations to you for this court's extraordinary work over the past 3 decades. The continued success of the South African Constitutional Court is a testament to your unwavering commitment to democracy, the rule of law, and the protection of fundamental human rights. It is truly a privilege for me and my spouse, Justin Catherine Mandeville, to be here with you to honor this momentous occasion. We visited for the first time last year for a judicial exchange between this court and the Supreme Court of Canada. I continue to recount to colleagues how deeply your insights and experience impressed me. This court has played an essential role not only in shaping the democratic landscape of South Africa, but also in influencing the broader international community, and for that, we are all grateful. In the world of constitutional law, few documents have as much significance and influence as the Constitution of South Africa. Its drafting was a groundbreaking moment in human history, marking the transition from oppressive era of apartheid to a new chapter of inclusivity, justice, and reconciliation. The Constitution enshrines values that resonate globally, human dignity, equality, freedom, and democracy. Of all the features of South Africa's constitution, the preamble speaks to me the most. You know it better than I. We, the people of South Africa, it begins, recognize the injustices of our past. These are not words of convenience. They are words of conscience. They name what was done, and in naming it, they begin the work of repair. The preamble speaks of healing, unity, human rights, and freedoms. But it does so without turning away from the wounds of history. It is, in that sense, a declaration of moral clarity, one that few constitutions have dared to make so directly. I want to share something personal with you. I have your Constitution's preamble hanging in my office. It was a gift from Justice Albie Sachs from my visit last year. It serves as a reminder that our work for justice and equality is never done. These are not merely abstract goals, but rather values that must animate the decisions on our courts that courts are making every day. As a Canadian, I am proud of the modest role that our Charter of Rights and Freedoms has played in the development of your constitutional framework. Today, I would like to speak about a notable feature of both our Charter and your Constitution, the limitation clause. In Canada, Section 1 of the Charter provides that the rights it guarantees are subject only to, and I quote, such reasonable limits prescribed by law as can be demonstrably justified in a free and democratic society, end quote. The South African Constitution, Section 36, permits limitations only if they are reasonable and justifiable in an open and democratic society based on human dignity, equality, and freedom. Both of our legal traditions have adopted proportionality as the guiding principle for the application of these clauses. To me, our limitation clauses are notable because of their uniqueness on the world stage. Few other constitutions include such a clause, instead opting to guarantee rights in absolute terms. After all, why include a provision that permits the limitation of rights in the very same document that enshrines those rights? Does it not send the wrong message that rights are optional or easily set aside? Perhaps the South African drafters should have picked a different clause of ours to borrow. But the truth is that our two countries understand the wisdom of the limitation clause. We know that the limitation of rights is inevitable, whether it is acknowledged or not. In a society built on rules of general application, rights will intersect and they will conflict. When they do, public policy must embrace compromise. That is what it means to live in a complex, vibrant, and democratic society. What these clauses recognize is that even though the limitation of rights is unavoidable, the mode of limitation can be defined, constrained, and disciplined. That is our job as guardians of our constitutions. We oversee governmental power so that it curtails rights only when it is absolutely necessary to achieve a pressing, a substantial objective done in the least impairing way possible and proportionate to the government's salutary objectives. In this way, we ensure that governmental power remains subject to the rule of law. Justice Albie Sachs once said, and I quote again, "If I were to be stranded on a desert island and allowed to take only two constitutional elements with me, I would take human dignity and proportionality. In that simple image lies a profound truth. Dignity is the foundation of rights, but proportionality preserves them. It would have been easy for our constitutional drafters to simply say that rights are guaranteed without limits. Sounds nice, doesn't it? But it is an empty promise. What is much harder and far more important is guaranteeing that even when rights are limited, the rule of law never falters. Canadians are proud to share this unique constitutional feature with you and to develop this area of constitutional law alongside your court. I could go on about the elegant provisions that make up your Constitution, but my comments would be incomplete without discussing what your court has done to bring those provisions to life. Indeed, seeing echoes of our charter in your Constitution is a source of pride. But seeing the courage, creativity, and principle with which you have built on your jurisprudence is a source of real admiration. While the South African Constitutional Court is still relatively young in its 30th years, it has developed jurisprudence that is both influential and deeply respected. Your court has become a model for courts globally, particularly in its approach to interpreting and upholding constitutional values. Few courts have so consistently placed dignity at the center of their reasoning, or shown such clarity in recognizing that legal text must ultimately serve the lives of real people, not abstract ideals. When our court was faced with the important question of whether prisoners should have the right to vote, we drew on the wisdom of your words in August against South Africa, and I quote, "The vote of each and every citizen is a badge of dignity and of personhood. Quite literally, it says that everybody counts," end quote. When grappling with the difficult concept of impartiality, our court leaned on your idea in Irvin and Johnson Limited, that judicial impartiality is the keystone of a civilized system of adjudication. When we were asked whether it is constitutional to extradite individuals who may face the death penalty, we turned to Justice Chaskalson's profound maxim in Makwanania, and I quote again, "It is only if there is a willingness to protect the worst and weakest amongst us that all of us can be secure that our own rights will be protected," end quote. It reminds me of our court's recent decision in Bissonnette, where we struck down a provision allowing courts to stack parole ineligibility periods to keep offenders incarcerated without the possibility of parole for the rest of their lives. We refused to let anger guide our judgment. We stood firm, even when vengeance called louder than mercy, to the unwavering belief that human dignity is never extinguished. This judgment reminded us of the deeper purpose of constitutional justice, to protect principle, not popularity, to act with resolve, not retribution, to protect the worst and weakest among us, as Justice Chaskalson wrote, so that we can all be secure, that our rights are protected. And just as our court borrows from your insights, we are honored that our judgments sometimes influence yours. What has emerged is a relationship of trust, a form of judicial kinship that transcends geography. As far as long-distance relationships go, our works pretty well. We have not only read each other's judgments, we have reflected deeply on each other's values. Together, we lead in the area of living constitutionalism, the idea that the Constitution is not a relic for a museum, but a dynamic force capable of adapting and evolving as society progresses. On this 30th anniversary, we reflect upon what has been achieved with admiration, but also with hope for what lies ahead. The path of constitutional justice is never static. New technologies, shifting politics, global crises, and evolving norms all place new demands on our courts. But in this era of complexity and change, the importance of international judicial dialogue has only grown. The experience of South Africa and the jurisprudence of this court continue to serve as a guiding light. You have shown the world that constitutional law can be a tool of transformation, not just preservation. You have demonstrated that courts can be agents of hope, grounded in the reality of people's lives. And you have reminded us that legal reasoning, when paired with courage and compassion, can build bridges over even the deepest of historical divides. In closing, let me once again offer my heartfelt congratulations to the South African Constitutional Court on this extraordinary milestone. Your achievements in the past 30 years have been nothing short of remarkable, and your influence will only continue to grow. Thank you again for inviting me to join you today, and may we continue to work together for justice, for equality, and for human dignity. Thank you very much.
Thank you, Chief Justice, for your lucid presentation and for the continued support to our court. I'll remind you that we look forward to further engagement with you and your colleagues at your court. The next speaker, we have, it's session 3, it's going to be messages of support from the other courts. This presentation, each speaker has been given 5 minutes to just say a few words in support, not the 15 minutes that we have been using. They are aware of that. I'm not changing anything. The first speaker is the Honorable Chief Justice of Botswana, Honorable Chief Justice Kitlo Khetswe. Thank you.
Yes, thank you so very much, Madam Program Director. I will stand on the already established protocols, but I think it will be remiss of me not to recognize the presence of the former President of South Africa, His Excellency Thabo Mbeki, and I recognize his presence. Now, ladies and gentlemen, you see, when we come from Botswana, and you come to South Africa, and you want to pretend that you are a Chief Justice, you may fall into problems. There was a time I came here as part of a training process run by Sajay, and I was assigned an officer from the VIP protection. And we had a discussion in the vehicle. He asked me how many people are there in Botswana. I told him we were 2.3 million. Then he asked me whether we have a president. When I told him, yes, we have a president, of course. Then he asked me whether we had a cabinet. I said, yes, we do. He said, for 2.3 million people, what are they doing? So, I don't know, but I told him, yeah, we do. So I stand here humbled by the invitation that has been extended to us by my sister Chief Justice Maya. And my message will be very, very short. The invitation came in, I accepted. it was followed by a reprimand that will give you a slot, but you should only speak for 5 minutes. So I'm not going to breach that. And I recognize all of you here, colleagues. The other issue that I want to mention is that you see Botswana, meaning the people of Botswana, and South Africans are very, very close. During the times of apartheid, some of them came to Botswana as refugees, or they were just passing through as part of the cadres of the liberation movement. Some of them stayed in Botswana as professionals. They were teachers, and some of them were lawyers. I stand here very, very proud today because when I started law practice in Botswana, I worked in an office that was established by a former South African and none other than President Thabo Mbeki's brother, Jaman Mbeki. So that's why I started my law practice. And I'm here today because I learned from the great. I didn't see him myself. I saw his name in the office. I saw the book that, yes, I saw his handwriting. So, and that office is still there. It has produced 2 justices. One of them ended at the Court of Appeal, and the other is here today pretending to be a Chief Justice. Now, the dawn of democracy in South Africa in 1994 heralded a new era for constitutionalism, not only in South Africa alone, but also in Southern Africa in general. The Republic of Botswana shares a legal heritage with the Republic of South Africa, Lesotho, Eswatini, Namibia, and the Republic of Zimbabwe, all of whom, you see, this technology sometimes is a problem. Yes, I think I'm sorted. All of which have the Roman Dutch law as their bequeathed common law heritage. From the certification of the draft constitution to Makwanyane and the treatment action campaign cases through to the Zuma corruption case, the birth of the Constitutional Court of South Africa shortly after the liberation of the Republic of South Africa has had a profound effect on constitutionalism and human rights jurisprudence in all our jurisdictions. It has proven to be a torchbearer in constitutional jurisprudence. As Botswana, for instance, we have taken a further step, or the further step of having former judges from this court who sit in our Court of Appeal. We have 2 justices, my friend Edwin Cameron, and our sister Bess Nkambinde, who sit in our Court of Appeal. We have another justice from South Africa who sit in our Court of Appeal. We have also had relations with the South African courts, particularly through Sajay. Most of our judges who come in, and I was talking to Justice Majid this morning and Justice Matopo to say their job is awaiting them in Botswana to go and train more judges. And Justice, where is my sister? Your job is waiting in Botswana to come and teach judges. Therefore, the celebration of the establishment of the Constitutional Court of South Africa is as much our celebration as it is a celebration for the people of South Africa, the African continent and beyond. Like the founding president of this republic, that is the Republic of South Africa, Nelson Mandela once said in his autobiography, Long Walk to Freedom, "You have climbed the hill, but the journey is not yet complete. There are mountains of constitutionalism still to be climbed. And as our collective democracies, we face more human rights and constitutional challenges. I trust and I believe that this court, that is the Constitutional Court, when called upon to climb this mountain, it will, as it has always demonstrated, climb the mountain with renewed vigor. As a country, we share South Africa's strong democratic ethos. We know and we believe that meaningful development is not possible in an environment where the constitutional rights of the ordinary people are not respected and protected. South Africa in this regard, and through the Constitutional Court, has been, and it seems it will continue to be the case, commanded a leading and exemplary role. Botswana will soon be engaging in a constitutional review process, and one of the things being seriously thought about is the establishment of a constitutional court. Don't ask me whether a country with 2.3 million will need a constitutional court. Obviously, there will be a lot to learn from the South African experience. My friend, my sister, Lady Chief Justice Maya, I bring a congratulatory message from the government of Botswana, the people of Botswana, as well as from our judiciary. And we wish you and the Constitutional Court and the people of South Africa and the Justice of South Africa the very best going forward. Thank you so very much for your attention, and may justice and human rights prevail forever. Thank you.
Thank you, Chief Justice. I was just about to stand up. Thank you very much. Thank you for the message. The President of the Supreme Constitutional Court of Egypt, the Honorable Femi Boulos, is the next speaker who will also give us a message of support. Thank you.
Good morning, everybody. سيادة القضية مهندسة مايا رئيسة قضاة المحكمة الدستورية بجمهورية جنوب إفريقيا، أصحاب السعادة والمعالي أعضاء المحكمة الدستورية بجمهورية جنوب إفريقيا، السادة أصحاب السعادة والمعالي القضاة.
Channel 1 for English, 2 for Arabic, 3 for Portuguese.
السيدات والسادة الحضور الكرام، في هذا المقام المهيب وفي رحاب القضاء الدستوري الإفريقي أتشرف بأن أنقل إلى سيادتكم وإلى المحكمة الدستورية بجنوب إفريقيا أسمى آيات التهنئة والتقدير للمحكمة الدستورية العليا بجمهورية مصر العربية قيادة وقضاة بمناسبة مرور 30 عاما على تأسيس صرحكم القضائي الشامخ. السيدات والسادة، إن ما نحتفي به اليوم ليس مجرد ذكرى تأسيس مؤسسة قضائية دستورية، بل هو استدعاء لمسيرة نضال وطني إنساني اختارت فيها جنوب إفريقيا دولة وشعبا أن تجعل من القضاء الدستوري ركيزة لبناء ديمقراطية حديثة ومحركا لإرساء العدالة الانتقالية ومرجعية راسخة لمبادئ الحرية والمساواة وكرامة الإنسان. لقد نشأت محكمتكم في قلب لحظة فارقة من الزمن، ليس فقط في التاريخ الوطني لبلدكم بل في ضمير القارة الإفريقية بأسرها، لتكون تجسيدا حيا لقدرة القانون على ترميم الذاكرة وتصحيح المسار وبناء الثقة بين المواطن ومؤسسات الدولة. ومنذ نشأة محكمتكم لم تكن حارسا للنصوص فحسب، بل ضميرا يقظا لحماية التوازن بين السلطة والمواطن، وصوتا ناطقا بعدالة تخاطب الحاضر وتؤسس للمستقبل. السيدات والسادة، إن تعزيز دور المحاكم الدستورية في إفريقيا ليس مسألة قضائية فحسب، بل هو رهان حضاري على قدرة دولنا في الدفاع عن منظومة الحقوق وتثبيت دعائم الدولة القانونية وإعلاء صوت المواطن. إن مصر التي آمنت مبكراً بدور القضاء الدستوري وأسست محكمتها الدستورية منذ نحو 60 عاماً مضت، ترى في هذا المسار الإفريقي المشترك فرصة لتلاقي الخبرات وبناء جبهة قضائية موحدة قادرة على الإسهام في تكريس حكم القانون في عمق المشروع القاري. وبهذه المناسبة أستميح سعادة القاضية مايا مانديسا أن أطلع الجميع على توقيع بروتوكول تعاون قضائي هو الأول من نوعه في دولنا وبين محكمتينا. تم يوم الأربعاء الماضي توقيع اتفاقية بروتوكول يمثل مصر فيها المركز الإفريقي للدراسات الدستورية القائم على مسألة استضافة علماء وباحثين في القانون الدستوري من كل أنحاء العالم، فضلا عن القضاة هذه المحكمة، لنتدارس معا ونتبادل الرؤى والخبرات ونقابل التحديات التي تواجهها المحاكم الدستورية، ونستضيف من يرغب من قضاة المحاكم النظيرة في لقاءات مثمرة نعضد بها جبهة العمل الدستوري. هذه البشرى أزفها إليكم في هذه المناسبة، وأثمن غاليا الجهد الكبير الذي قامت به سيادة القاضية مانديسا مايا وكل فريق العمل معها في إقرار هذا المشروع. السيدات والسادة، إننا نؤكد من هذا المنبر دعمنا لتعميق التعاون بين المحاكم الدستورية في قارتنا. نرى في هذا المسار ركيزة من ركائز المشروع الإفريقي المشترك نحو الاستقرار والتنمية وتكريس الحكم الرشيد، وذلك من خلال تعزيز الآليات القضائية وتبادل الخبرات وتطوير الحوار الدستوري العابر للحدود بما يخدم قضايا القارة وتطلعات شعوبها. ختاما أيها السيدات والسادة، أجدد باسم المحكمة الدستورية العليا بجمهورية مصر العربية التهنئة الصادقة والتقدير العميق لمحكمة جنوب إفريقيا الدستورية قيادة وقضاة، متمنين لكم دوام التوفيق في حمل الأمانة العظيمة وإعلاء شأن العدالة الدستورية خدمة للإنسان وصونا للمؤسسات وتكريسا لقيم نتقاسمها جميعا. والسلام عليكم ورحمة الله وبركاته.
Thank you very much, Chief Justice. The Chief Justice of the Kingdom of Eswatini, Honorable B. Mpalala, will you kindly come over, please? Thank you. Yes. Oh, no. Let me take this one.
President Mbeki, my lady, the Chief Justice, all protocol observed. Before I make my brief speech, let me congratulate the Judiciary of South Africa for the statements that was made this morning by the President of South Africa with regard to judicial independence. Congratulations. I will address you in my capacity
as the chairperson of the Southern and Eastern Africa Chief Justices Forum. We meet here today to celebrate a great milestone of achievement by the Constitutional Court of South Africa. This achievement has been evident and reflected in the quality of judgments made in pursuit of the promotion and protection of fundamental human rights and freedoms of the people of this country. As we celebrate this day, we should acknowledge the reality that the Charter of the United Nations is ineffective. The Charter constitutes foundational treaty of the United Nations. The Charter mandates the United Nations and its member states to maintain international peace and security, uphold international law, and promote universal respect and observance of fundamental human rights and freedoms for all without distinction. However, the genocide committed in Gaza and the West Bank is testimony to all that the United Nations is not living up to its obligations. The Charter embraces the principle of sovereign equality of all its members as well as self-determination. However, the principle is not observed by the United Nations pursuant to the provisions of the Charter. The Charter embraces the Security Council as one of its principal organs, with 5 permanent members having veto powers. And this provision negates the principle of sovereign equality of member states. Accordingly, the Security Council is not capable of executing its mandate of maintaining international peace and security objectively without embracing the individual narrow interest of the permanent members of the Security Council using its veto power. Furthermore, the Universal Declaration of Human Rights, together with the International Covenant on Civil and Political Rights, have not benefited the African continent, the people of Gaza and the West Bank, as well as the developing world, notwithstanding the existence of the International Court of Justice, which is another principal organ of the United Nations. In terms of Article 59 of the Statute of the International Court of Justice, the court's decisions are binding on parties with respect to the particular case. However, you are all witnesses that the decisions of the ICJ are ineffectual because the court lacks the enforcement mechanism to execute its decisions. I think the judiciary is aware what happened last year at The Hague when South Africa presented its case. As I conclude my speech, I would like to state that member states of the African continent have succeeded in obtaining their political independence from colonialism and imperialism. However, the economic independence of the African people remains a hollow dream due to neocolonialism. The colonial masters have returned to Africa to loot the natural resources of the African people, leaving the African people in abject poverty. What is happening in the Democratic Republic of the Congo, Libya, and many other African countries explains the puzzle why the African people remain poor when the continent is endowed with so many natural resources. May I, before I sit down, congratulate you, my lady, the judiciary, for this important occasion, and also for inviting us to be part of this ceremony. I thank you, and may God be with you.
Thank you, CJ. You even have a minute left. I'll call upon the President of the Constitutional Council of Mozambique, Excellency President El Ribeiro, to the stage. Thank you.
Good afternoon. Thank you. Her Excellency Mandisa Maya, President of the Constitutional Court of South Africa, Excellency President Thabo Mbeki, all protocol observed. My first words in the name of the Constitutional Council of Mozambique and mean to both thank and congratulate you on the occasion of today's 30th anniversary of the Constitutional Court of the Republic of South Africa. And a very sincere thank you for the great honor for being invited to address you for such a fortunate reason in this podium. Also, on this occasion, my earnest greeting to you all. To Her Excellency Mandisa Maya, President of the Constitutional Court of South Africa, and to the Justice, I extend my greetings of continued success in your noble role in favor of constitutional justice, peace, stability, and democracy in your country and in the region in particular. And I encourage you to continue the brilliant trajectory of this august institution, which over these 3 decades has been a living testimony to the resilience of the constitutional justice, even in the face of the most complex political, social, and historical challenge. Excellencies, ladies and gentlemen, celebrated 30 years of the existence of the Constitutional Court is an institutional event that means the celebration of courage and sometimes challenge journeys and milestones that call for deep introspection and reflection. South Africa's Constitutional Court was created at the dawn of democracy, a crucial moment in the country's history as one of the fundamental pillars of the new social pact established with the Constitution, internationally recognized as one of the most progressive in the world because it affirmed the fundamental rights and idea of the centrality of human dignity, equality, and freedom, not as an abstract ideal, but as a concrete response to the deep wonders for the past. And since then, the Constitutional Court has taken up the role of guardian of this new social contract, ruling in emblematic cases that have shaped the course of South Africa's society, promoting justice, reconciliation, and respect for the fundamental rights. So much so that its 3 decades of jurisprudence is an obligatory reference in academic and judicial circles in the continent and beyond. South Africa's Constitutional Court has been a torchlight for emerging democracies, providing that it is possible to build a strong institution in a context of great social, cultural, and political diversity. Excellencies, honorable guests, allow me to make a few remarks about the proximity between Mozambique and South Africans. We are a brotherly nation, united by the history of a struggle against the oppression and by the commitment to the self-determination, freedom, and justice. Geographical borders are more tenuous than these historical ties I mentioned. We share the dreams of liberation from segregationism and colonialism. We have consented to mutual sacrifice in favor of these goals. Solidarity between our people has been marked by political, military, and humanitarian support. In this solidarity, we remember, among others, and greet with particular respect and admiration the Honorable Justice Albie Sachs, who was the victim of an attempt on his life in Mozambique territory. The victory we celebrate today, such as the construction of democracy, states, and the creation of the institution that guarantee the fundamental rights of our citizens, are the fruits of this historic solidarity. In this context, the celebration of the 10th anniversary of the Constitutional Court of South Africa should be an opportunity to reaffirm these deep ties through judicial cooperation and the exchange of jurisprudential experience. Compared to the sum of its African counterparts, Mozambique Constitutional Council is still a young jurisdiction. Our first constitution, which coincides in time with the national independence on 25 June in 1975, is now complete 5 decades old. But the separation of power and the institutionalization of the Constitutional Council was promoted by the second Constitution of 1990. However, the Constitutional Council came into being 30 years later on 3rd of November 2003. In these short journeys, we have found inspiration in the commitment of the region courts in general and South Africa's Constitutional Court in particular to defense of fundamental rights and guarantees. Having already made an invaluable contribution to the definition and affirmation of our rule of law, the challenge we have faced requires institutional courage, interpretative wisdom, and constant dialogue with the society. So, as a final note, I would like to express my hope that this celebration will lead to a deepening of cooperation between our courts through forums for dialogue, exchange of case law, joint training, and sharing of good practice, renewing our commitment to judicial integrity, impartiality, and independence, values without which there can be no true constitutional justice. And may our courts remain institutions where the most vulnerable find protection, active institution in preserving the rule of law, institution of civic courage and fidelity to the Constitution, which are the voice of legality, justice, and hope. Muito obrigada pela atenção dispensada.
Thank you very much, Chief Justice, President of the Court. Honorable Chief Justice Chivute, the Chief Justice of Namibia, I call upon you now to make your message of support. Thank you.
Your Excellency, former President Mbeki, the Honorable Justice Maya, the Chief Justice of the Republic of South Africa, the Honorable Acting Deputy Chief Justice of South Africa, Your Excellencies, Presidents and Chief Justices of Constitutional Councils, Constitutional Courts, and Supreme Courts, distinguished ladies and gentlemen, I stand before you to join you with a distinct, which I consider to be a distinct honor in commemorating the 30th anniversary of the Constitutional Court of South Africa, a court that has since its inception played a key role in advancing constitutionalism, justice, and the rule of law in South Africa and across the region. The establishment of this court marked more than the creation of a new institution. It signaled a profound shift, a turning point in the country's legal and moral landscape. At a time when public confidence in the justice system needed rebuilding, this constitutional court emerged as a stabilizing force, principled, deliberate, and committed to ensuring that the rule of law would anchor the new democracy. Its role in helping to shape and secure South Africa's constitutional transition is widely recognized and remains a point of reference for many, including for those of us in Namibia, where our courts faced similar demands during the early years of constitutional implementation. Namibia and South Africa share more than just a geographical border. Our histories are intertwined, our peoples linked by a shared struggle for dignity, equality, and justice. With closely related legal systems, we have often looked to each other in our respective journeys of transition and legal development. In many respects, our legal systems have evolved alongside one another. In that spirit, Namibian courts have consistently drawn on the jurisprudence of this court, often finding in its judgments and both legal clarity and principled reasoning that resonates with our own constitutional framework. In fact, such had been the proximity to closeness of our two jurisdictions, that at one point in our histories, to be exact, from 1997 to 1999, our countries shared Chief Justice Ismail Mohammed as the Chief Justice of South Africa and Namibia, and I may add for emphasis, at the same time. Indeed, the Constitutional Court of South Africa has long served as a persuasive voice in the Namibian legal context. Its decisions have been cited across a wide range of matters. What distinguishes this court's body of work is not only the intellectual rigor it reflects, but also the way it grapples earnestly with the lived realities of those affected by the law. Another hallmark of the court's legacy is the manner in which it has persevered its independence, or preserved rather its independence, while remaining accessible and accountable to the people it serves. Maintaining that delicate balance is no small feat, particularly in an area or in an era when courts around the world are increasingly drawn into matters that touch on sensitive political and social questions. Yet, it's precisely this balance that sustains public confidence and affirms the judiciary's role as a neutral guardian of the constitutional order. It would be remiss of me not to take this opportunity to once again congratulate Justice Madisia Maya on her well-deserved appointment as Chief Justice of South Africa. Her elevation is significant, not only as the first woman to hold this esteemed office, but also as someone whose judicial journey reflects dedication, distinction, and a deep commitment to the rule of law. We look forward, Madam Chief Justice, to the continued evolution of the Constitutional Court under your stewardship. To the court itself, congratulations on this remarkable milestone. 30 years of jurisprudential leadership, courage in the face of social complexity, and an unwavering commitment to the Constitution is no small feat. Congratulations on the 30 years of dedicated service to the Constitution and to the people of South Africa. May the years to come be marked by the same independence, insight, and integrity that have defined the court's first 30 years. May it continue to serve as a forum where justice is not only done, but seen to be done, and where the Constitution is not simply persevered or preserved, but animated in the service of the people. Thank you.
Thank you very much, Chief Justice. I know we have now almost taken time, which should have been reserved for lunch, but I think there are only 2 speakers remaining, and I propose that we finalize that before we break for lunch. I call upon the Chief Justice of Nigeria, the Honorable Kekere Ekun, to make a few messages of support. Thank you.
Thank you. The former President of the Republic of South Africa, Mr. Thabo Mbeki, Chief Justice Mandisa Maya, distinguished guests, ladies and gentlemen, it is with profound honor and deep respect that I stand before you today representing the judiciary of the Federal Republic of Nigeria to extend warm congratulations on this landmark occasion, the 30th anniversary of the Constitutional Court of the Republic of South Africa. 3 decades ago, this court emerged as a beacon of justice and constitutional renewal in a country that had chosen with courage and conviction the path of democracy, equality, and the rule of law. Since that transformative moment, the Constitutional Court has stood not only as the guardian of South Africa's constitution, but as a source of inspiration across the continent and beyond. In this court's jurisprudence, we have witnessed the power of law to heal a nation, to confront injustice, and to advance human dignity. Through fearless adjudication, judicial independence, and unwavering fidelity to constitutional values, you have demonstrated the capacity of courts to be agents of social transformation. Your landmark judgments continue to echo far beyond South Africa's borders, affirming that the Constitution is not merely a legal document, but the living embodiment of the people's collective will and aspirations. As fellow custodians of the rule of law, the Nigerian judiciary has drawn deep inspiration from your pioneering decisions and principled stance in defense of democratic ideals. Your work reminds us all that the constitutional courts play a vital role, not just in resolving disputes, but in shaping just societies. I'm especially honored to deliver this message, having recently had the privilege of visiting Cape Town in April this year to attend the 17th Biennial Conference of the International Association of Women Judges, IAWJ, where my fellow delegates and I were graciously received by His Excellency President Cyril Ramaphosa and the Honorable Chief Justice Maya. That visit deepened my appreciation of your country's remarkable legal heritage and enduring strength of your institutions. Today's celebration stands as a powerful affirmation that the Constitutional Court remains a beacon of constitutionalism and judicial excellence on the African continent. On this joyous anniversary, I salute the founding justices whose vision laid the foundation for this great institution, the current justices for their continued service with distinction, and all who have contributed to the court's legacy of justice, courage, and excellence. May the Constitutional Court of South Africa continue to flourish, to inspire, and to uphold the noble ideals upon which it was founded for this generation and those yet to come. Thank you most sincerely, and congratulations.
I salute you, Chief Justice, for the promptness and keeping time to time. Thank you. Honorable Mr. Justice P. Mithal from the Supreme Court of India. I think he's going to be speaking on behalf of the Chief Justice of India. Thank you.
Namaste. A very good afternoon to all present in this auditorium. Honorable Chief Justice, Madam Maya, my esteemed justices of the Constitutional Court of South Africa, dignitaries on the dais, distinguished guests, ladies and gentlemen. It is with immense respect and heartfelt gratitude that I stand before you today, here in the Republic of South Africa, to commemorate 3 decades of the Constitutional Court of South Africa, a beacon of constitutional justice in the modern world. I bring with me warm greetings and deep administration from the Supreme Court of India and from the people of my country who share with South Africa a special bond, grounded in history, independence, struggle, and our common constitutional aspirations. 30 years ago, South Africa took a courageous step, emerging from the long shadows of apartheid to embrace a future rooted in dignity, equality, and constitutionalism. That moment marked not just a formation of a court, it marked the birth of a moral institution committed to rebuilding a fractured nation through the rule of law. The Constitutional Court of South Africa has emerged as a beacon of democratic values, a fearless guardian of constitutional morality, and a global symbol of how law can heal the wounds of an oppressive past. When Mr. Nelson Mandela came to inaugurate this august building of immense national importance on 14 February 1995, in his speech, he said, and I quote, "Today, I rise not as an accused, but on behalf of the people of South Africa, to inaugurate a court South Africa has never had, a court on which hinges the future of a democracy," unquote. India and South Africa share more than diplomatic ties. We are united by a shared constitutional spirit. Both our nations, born from movements against injustice, have placed human dignity and social justice at the heart of our constitutional frameworks. Our courts, though shaped by different contexts, have been animated by a common vision that the Constitution must be a transformative force, not a static charter. India and South Africa are sister democracies born in pain but determined to forge paths bounded in liberty, dignity, equality, and fraternity. When India gave unto itself a constitution in 1950, it was deeply conscious of global trends. Our constitution makers took note of the South African framework of 1910, particularly in designing a stable yet flexible amendment process and a federal structure that balances unity with regional diversity. Our Article 368, with its requirement of a 2/3 majority mirroring South Africa's approach, ensures that constitutional changes remains principled and deliberative. Similarly, our Rajya Sabha, the Council of States, reflects South Africa's model of indirect election through proportional representation, giving voice to the regional aspirations and strengthening the union. We borrowed from you, and over a time, I dare say that you also drawn from our journey, creating beautiful symmetry in constitutional growth rooted in a common goal of inclusive justice. The establishment of a constitutional court in 1994 was not merely a procedural innovation, it was a moral reclamation. Under the inspiring leadership of figures such as Justice Arthur Chassaman and Justice L.B. Sachs, who brought to the bench their lived resistance in injustice, South Africa reimagined what judiciary can be, not merely as an interpreter of laws, but a protector of constitutional soul. The efforts to diversify the bench, elevate black and female jurists, and transform legal culture have borne visible fruits. The court today stands not only as an adjudicatory body, but as a symbol of democratic renewal. As an Indian judge, I recognize in this transition echoes of our own journey post-independence, though the velocity and depth of South Africa's change is extraordinary and worthy of global emulation. The Constitutional Court, built with bricks from the dismantled prison, is now a monument of freedom that protects the liberty of every individual. The windows behind the judges gives a glimpse of every feet of those outside walking by. It is a daily visual cue that the power of judiciary comes from the people and which reminds that the role of judges is to act in the interest of the people of the nation. The Constitutional Court's judgments have echoed far beyond South Africa's border. In Maikana, the court abolished the death penalty, aligning with the global human rights trends and drawing from the Indian Supreme Court's own jurisprudence in Bachan Singh's case, which restricted capital punishment to the rarest of the rare. The emphasis on human dignity and disproportionate impact on the marginalized is a lesson for all jurisdictions struggling with moral weight of state-sanctioned death. In Government of Republic of South Africa versus Grootboom, the court breathed life into socio-economic rights. The right to adequate housing was no longer aspirational. It became a justiciable right. In India, Olga Tellis foreshadowed this idea by linking livelihood with life, but our enforceable framework has become an example for global South nations navigating the tensions between resource limits and constitutional commitments. Most importantly, in economic freedom fighters' case, the Constitutional Court ruled in the illegal and costly security upgrades. In this case, the Constitutional Court insisted on executive accountability of ECOS, the Indian Supreme Court's own robust intervention in upholding institutional integrity, such as in the second judge's case. Your judiciary's courage in ensuring that no one, not even the president, is above law is both humbling and inspiring. Nelson Mandela and Mahatma Gandhi, two titans of moral resistance, stand as bridges between our histories. Gandhiji's early experience in South Africa shaped the philosophy of Satyagraha, which go on to inspire freedom movements across the globe, including Mandela's own journey. Mandela often referred to Gandhiji as a sacred warrior, and their legacies remind us that non-violence, truth, and compassion are most powerful tools of justice. As an Indian in South Africa, I cannot help but to feel a sense of homecoming. Mahatma Gandhi spent 21 formative years in this country. It was in Pittsburgh that he was thrown out of train, and it was on your soil that he founded his mission. The seeds of Satyagraha, non-violent resistance, were sown in South Africa. In the spirit of Ubuntu, I am because we are. I am because we are. Let us commit to deeper judicial dialogue, mutual learning, and solidarity, for justice is not a solitary pursuit. It is a collective enterprise that binds humans together. I conclude with the words of Mahatma Gandhi. I quote, "In a gentle way, you can shake the world. In a gentle way, you can shake the world." The Constitutional Court of South Africa has indeed shaken the world, gently, wisely, and enduringly. Today, as we mark the 3 decades of Constitutional Court of South Africa, we honor its bravery, wisdom, commitment, and to transformative justice. It has walked with the people, listened to their pain, upheld their dignity, and advanced their freedom. And the journey ahead is equally promising. As my floor timings coming to end, I am reminded of India's leading judicial minds and the architect of the Indian Constitution, Dr. B.R. Ambedkar, who in one of his Constituent Assembly speeches said, "The Constitution is not merely a document, it is a living soul that breathes justice, liberty, and equality." On behalf of the Supreme Court of India, I offer my deepest congratulations to the judges of this remarkable court. May your flame of justice continue to burn bright for South Africa, for Africa, and for the world. Thank you. Vai Danki, Jayati, Jayati, Mam Bharatam.
Thank you. He is the messenger. So thank you very much. The Chief Justice of the Supreme Court of Kenya, Mr. Justice Lenwala. Thank you.
Thank you,
Director of Ceremonies, President Becky, Chief Justice, colleagues, good afternoon. Good afternoon, please. I know that I'm between you and lunch, so I'll be exceedingly brief, lest I be accused of flouting the right to food. Chief Justice, I bring greetings from the Chief Justice of Kenya. My elder brother, Justice Moseneke, this morning congratulated me on my appointment as Chief Justice. So have you, from your lips to God's ears. I am of the Supreme Court of Kenya. I represent my Chief Justice, Martha Koome, who could not come. So receive her greetings and congratulations. Number two, I want to thank this court for the work you've done over the last 30 years. We in Kenya are beneficiaries of your jurisprudence, and particularly myself. I was the head of the Constitutional Human Rights Division of the High Court until I rose to the Supreme Court. And between 2010 and 2016, I cannot remember the number of times, I quoted Makanywane, 51 Olivia Road, Bywatch Trust judgments, and many others. And so we thank you for laying the foundation for our court, which is only 12 years old. We were set up in 2010 after our new constitution, and as some of you may know, the Bill of Rights in our constitution is heavily borrowed from your Bill of Rights, and therefore our interpretation and application of the Bill of Rights borrows heavily both from your constitution and of course your jurisprudence. Having so said, I also want to thank some of the judges of your court who were instrumental in bringing Kenya to peace and to stability. Judge Johan Kriegler, we thank you. When you came after the tribal clashes of 2007, 2008, you laid the foundation for what we have today as our electoral system. And as we go to elections in 2027, your spirit, your words linger, and they remind us of the need to retain peace if we are to have a true democracy, as we must all aspire to. I want to thank you. I want to thank you, Justice Albie Sachs. You came to Kenya again after 2010 as part of a panel that was vetting all judges sitting in Kenya at the time, including myself, to determine our suitability to serve under the new constitution. And it was part of that process that triggered what we are calling today in Kenya true transformation of our judiciary, from a judiciary of corruption, a judiciary of incompetence, to a judiciary today celebrated like yours across Africa. We thank you, Albie Sachs. Number three, Chief Justice, a few years ago, we had a joint program between your court and our court, where your law clerks would come to Kenya, and our law clerks would come here. That program collapsed. I now plead with you from this podium, President Becky, please tell her to listen to me. Let us revive that program. I'm a beneficiary of that program because my law clerk came here, clerked for Justice Moseneke, introduced me to Justice Moseneke, who has remained a good friend since my law clerk came here. If we could please revive that program, it would be useful to both our courts and to develop our young lawyers. And while I'm on that, Chief Justice, we may need to have an MOU in terms of training, in terms of exchange of ideas and jurisprudence between our two courts. And since I lead in the program of engaging with international courts, I hope that before I go, you can give me one of your judges, we can have a drink in the evening, and draft one MOU which we'll share with you and our Chief Justice. And I can go with a draft to my Chief Justice, and we get this going. Lastly, I promise to be brief. Lastly, I wish this great court, under your leadership, Chief Justice Maya, more years of great leadership in creating indigenous African jurisprudence, and may the spirit of Ubuntu bind all our courts to greater success. And so I thank you for listening to me, and I hope when I go back to Kenya, I can carry your greetings to the Supreme Court of Kenya, to my Chief Justice, and the great people of the Republic of Kenya. I thank you.
Thank you very much, Justice. And on the law clerks issue, we are definitely working on that. It's trying to get funding. I'm talking my head as the chairperson of the Constitutional Court Trust. We're definitely working on that. Now, thank you to the audience for your patience. We should have adjourned for lunch a long time ago. We are now going to adjourn for lunch. It will be a 30-minute break. On my clock,